welcome you to the Washington Legal Foundation's web seminar series. I'm Glenn Lammy, Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation's work, we are in our 37th year of public interest law and legal policy advocacy and education, in addition to litigating in all levels of the federal and state courts, which is what we started out as 37 years ago, a litigating group. We also publish on a wide range of topics, legal and policy related to the free enterprise system. In addition, we put on programs such as this one, media briefings as well, and our blog, the WLF Legal Pulse, covers many of the same issues that we do through our publications. If you have any interest in looking more into the Foundation, I encourage you to stay on the website after the program is over and take a look around, and I'm happy to answer any questions that anybody might have after the program. Speaking at Duke University in November 2010, attorney Stephen Donziger told a group of law students, "I don't see a model in the nonprofit world where you could actually bring a lawsuit like this and sustain it over time against a big oil company. We wanted to make this a business model for human rights cases." The outside world, Mr. Donziger and his international ensemble of lawyers, consultants, financiers, and movie makers seem to have designed and carried out a model lawsuit, first against Texaco, then Chevron, for alleged environmental degradation in the Ecuadorian rainforest. But on the inside, the litigation crusade was rotten, a reality which came to light when the determined defendant fought back. The story of Aguinda v. Chevron is, as they say, the stuff of books and movies. One of our panelists today has in fact authored a book on it, which is eventually going to be made into a movie. Our other panelist has the luxury of being an outside observer to the Aguinda versus Chevron case itself, as an insider, as well as lead defense counsel in another lawsuit that seems to have been inspired by or taken some cues from Donziger in his case. We're pleased to have them both with you today to offer some lessons on the case and thoughts on the impending Second Circuit appeal of the RICO action Chevron won against its antagonists earlier this year in the Southern District of New York. Leading off will be Paul Barrett, who is Assistant Managing Editor and Senior Writer at Bloomberg Businessweek, a position he assumed in September of 2005. Prior to joining Bloomberg Businessweek, Mr. Barrett was an editor and legal affairs reporter for the Wall Street Journal. He has held the position of Supreme Court reporter, Page One Special Project Editor, and Page One News Editor. Mr. Barrett's book, to which I alluded previously, which is Law of the Jungle, was released on September 23rd. Joining us as well is Eric Lasker, who is a partner with the law firm Hollingsworth LLP here in Washington, D.C. Mr. Lasker litigates a wide variety of complex civil matters with a current focus on toxic torts, environmental litigation, alien tort statute litigation, and pharmaceutical products liability. He was recognized by the American Lawyer as Litigator of the Week and featured on the Bloomberg News program Rainmakers for his work in securing a victory for Hollingsworth and its client DynCorp International in the case Venancio Aguasanta Arias versus DynCorp. If you have any questions for us, we are pleased to have you submit them to interactive@wlf.org. I will be asking questions and also fielding questions from the audience online if you have any. Paul, you can get us started.
Well, thank you very much, Glenn. I'm glad to be here at the Washington Legal Foundation. And I think what I'm going to do is give an overview of the story behind this extraordinary case, and then offer a few very quick kind of bullet point lessons for large corporations, litigators, environmentalists, and so forth. So let's begin with two colliding court judgments. In February of 2011, plaintiff's attorney, to whom Glenn referred, Stephen Donziger, won a $19 billion verdict against Chevron, the biggest environmental verdict of its kind ever anywhere in the world, and remarkably, it was the one and only civil lawsuit that Stephen Donziger had ever filed. An extraordinary achievement, or so it seemed. Almost exactly 3 years later, in March 2014, a federal judge in New York ruled that this Ecuadorian verdict was a complete sham, based on fabricated evidence, forged documents, coercion, and bribery. My book, Law of the Jungle, is about these two irreconcilable judgments, how these judgments reflect our typically irreconcilable views of big oil companies, of developing societies, of crusading class action lawyers, of the ability to use the rule of law to hold multinational corporations accountable. I try in Law of the Jungle to make sense of these irreconcilable judgments and to make the point that what may seem like a classic David and Goliath parable in fact turns out to be something else, because this is a story about a campaign to save the rainforest that went horribly awry. In the 1960s, Ecuador sought outside investment to take advantage of the tremendous natural resources in the rainforest region known as El Oriente in the northeastern portion of the country. Texaco, later acquired by Chevron, answered Ecuador's call and signed a series of agreements with the Ecuadorian government and began producing oil in the early 1970s. The oil was drilled in the rainforest, sent up over the Andes through a pipeline to the Pacific coast, and then shipped to California. That pipeline, at the time, was one of the engineering feats of Latin America. The oil industry became the backbone of the Ecuadorian economy. Aggregate living standards improved, life expectancy improved, infant mortality decreased. There were a lot of benefits from the oil industry. Roads were paved, villages got electricity. A middle class grew in Quito, the capital, as the oil industry created white-collar jobs. Unfortunately, as Ecuador became wealthier overall, economic inequality in Ecuador worsened. In relative terms, its poorest citizens grew poorer. And the poor people living near the oil operations in El Oriente suffered severe environmental side effects from the unregulated industrialization of the rainforest. Texaco, and I want to make this point emphatically, left a mess behind. The company dug hundreds of Olympic swimming pool-sized waste oil pits that were unlined and just left behind. These were earthen and had no lining. The company discharged billions of gallons of tainted production water. That's the water that comes up when you produce oil from underground. And Texaco discharged this water into the streams and rivers that people used for drinking water and where they bathed their children. Texaco was aware of what it was doing. In my book, I describe internal memos wherein company executives actually considered lining these waste oil pits, put a price on it, $4 million. And then they said, no, why spend the money? We don't really have to do that. Ecuador is not requiring us to do it, so we won't do it. The Ecuadorian government was also aware of what was going on, as correspondence from that period shows, and did nothing. And it's important to emphasize, as is often the case with the exploitation of natural resources, the host country actually kept the vast majority of the proceeds from this industrial activity. Some $25 billion were generated in the 1970s and 1980s. 90% of it stayed in Ecuador, government records show. Now, how could that be? Well, it's because for the vast majority of that time, the Ecuadorian government owned 2/3 of the joint consortium producing the oil. So Ecuador was actually selling most of the oil. Moreover, Ecuador imposed very steep taxes and royalty payments on Texaco, and as a result, the vast majority of the riches from this oil stayed in Ecuador. What was done with it is another question. In the early 1990s, Ecuador nationalized its oil industry and sent Texaco packing. Texaco returned home to New York, where it was based at that time, to a plaintiff's lawyer welcome, a class action lawsuit filed in New York in 1993 seeking $1 billion in damages for the ecological harm attributed to Texaco. Texaco fought this lawsuit on procedural grounds. Since many of the people in this audience will be lawyers, I'll use the technical term, forum nonconvenience. Texaco argued to the U.S. courts, this case, if it belongs anywhere, belongs in Ecuador, where, Texaco argued, there's a perfectly respectable judiciary that is capable of assessing the alleged victims, the alleged evidence, and all of that is down in Ecuador. In 2001, just as Chevron was taking over Texaco, the U.S. courts granted the oil company its wish, dismissed the case, and basically said to Texaco, at this point becoming Chevron, you want to go to Ecuador? Go to Ecuador. And the lesson here for large corporations is be careful what you wish for. There's a strong argument to be made that possibly Texaco and Chevron should have resolved this situation in the U.S. courts rather than trying to get it dismissed, because once they got to Ecuador, they encountered a situation far different from what they're anticipating. Chevron assumed that the plaintiffs' lawyers who had brought this case would be exhausted in 2001, 2002, financially, psychologically, and otherwise. The oil company assumed that if the case ever were refiled in Ecuador, it would go nowhere because the courts in Ecuador, they assumed, had no jurisprudence for mass litigation. Finally, the oil company assumed that the historically right-leaning politics of Ecuador would favor corporate interests. In fact, Chevron miscalculated on all of these fronts. The politics of Ecuador were at that time swinging from right to left. By 2006, the country had elected a distinctly leftist populist president who still is in office today, Rafael Correa, who became a big backer of the lawsuit against Chevron, made it a political issue in the country. In 1999, while Texaco was still fighting over forum nonconvenience in the Second Circuit of New York, the plaintiffs' lawyers had actually very quietly gone to Ecuador and consulted with Ecuadorian legislators on how to draft a law that would allow for class actions for the first time. And in 1999, a law called the Environmental Management Act was enacted. So now there was a vehicle for this kind of action. And the biggest miscalculation Chevron made was failing to appreciate the ascendance of Stephen Donziger. Donziger had been the junior-most lawyer on this team when the original complaint was filed. His name was on the complaint, but he was the bottom man. He was mostly the media impresario, the guy who would organize the press conferences where Ecuadorians in traditional dress would come to the steps of the courthouse in Foley Square and so forth. But he was a very, very enterprising person, a former reporter, a former prisoner activist. Then he went to Harvard Law School where he was friends with Barack Obama. And he, over time, shouldered aside the older lawyers, the more experienced lawyers who had originally brought the suit, and he proved to be a wizard at marshaling celebrity backing and media attention. You had celebrities ranging from Sting, his wife Trudy Styler, Bianca Jagger, Daryl Hannah, Mia Farrow, even Cher lent their name to this cause at one time or another. Major media outlets portrayed Donziger's crusade in extremely sympathetic terms, whether it was Vanity Fair, the investigative television show 60 Minutes, CNN, or the documentary film Crude, made by a prominent documentarian named Joe Berlinger, who Donziger had sought out and actually helped finance Berlinger's film, which debuted at the Sundance Film Festival in 2009. He helped finance it in that he introduced Berlinger to another Harvard Law School colleague of his, a guy named Russ DeLeon, who in the interim had become a billionaire online poker magnate, and he invested millions of dollars in the lawsuit in exchange for a share of the recovery, and also helped finance the movie in exchange for a producer credit on the movie. So in this sense, Donziger, at least for many years, was quite the impresario in terms of attracting attention, creating momentum, and keeping Chevron on the run, at least in the court of public opinion. In the actual court in Ecuador, he employed all kinds of avant-garde legal tactics. Persuaded that the only way to take on a major oil company was to bend the rules, or as he would put it, fight fire with fire, he cajoled and bullied Ecuadorian judges in private. He submitted scientific evidence he knew was faulty because his own experts told him it was faulty. He bribed and manipulated a supposedly neutral court-appointed expert whose work Donziger had had his own American technical advisors ghostwrite. They ghostwrote this crucial damages report in the first person in English, then had it translated into Spanish, shipped it down to Ecuador. Only days before it was to be submitted, the supposed independent court-appointed expert took this multi-thousand-page document, went into the courthouse and swore to the judge, "This is my independent work." Donziger's experts then drafted challenges saying that the report they themselves had drafted did not provide sufficient damages. They then ghostwrote the experts' responses to their own challenges, thereby bidding up the damage level over and over. Because, of course, they were bidding against themselves. Worse than all of that judicial corruption, all of that legal corruption, in my view, as I write in the book, is the fact that all through this period, Donziger was actually lobbying the Correa government not to clean up the oil pollution, to leave it in place. Why would he do that? He would do that to maintain a foundation, a factual foundation for his lawsuit, and to maintain what I think of as the cinematic backdrop for all of that celebrity activity, documentary filmmaking, television segments, and so forth. Without waste oil pits, where's the drama? In February 2011, to come back to where I started, these efforts paid off, for better or for worse, with that $19 billion verdict. But Chevron was not done. The very same month, February 2011, Chevron took the unusual step of filing suit against Donziger personally and against his clients under the civil racketeering law in the United States, and they filed that case back in New York. Chevron made an audacious demand. They said, we want to see the field tapes from that documentary film that Mr. Donziger helped arrange, that he solicited and helped finance. And after an extraordinary discovery fight that involved fascinating First Amendment questions, a federal judge in New York said that the filmmaker had to turn over 600 hours of field tapes, so-called outtakes. It turned out that for a period of years, Donziger had allowed the documentary filmmakers to follow him around, to film even private meetings, to film, for example, a meeting where he recruited and was prompting the supposedly neutral court-appointed Ecuadorian expert at a plaintiff's lawyer meeting before the expert had even been officially appointed. In March 4th of this year, Judge Lewis Kaplan issued his 485-page ruling in Chevron versus Donziger, the RICO lawsuit. Judge Kaplan said, quote, the plaintiff's team wrote the Lago Agrio court's judgment themselves and promised $500,000 to the Ecuadorian judge to rule in their favor and sign their judgment. In other words, a sham judgment in Judge Kaplan's terms. That is what the American court system thinks of what transpired in Ecuador. Judge Kaplan continued, quote, this case includes things that normally come only out of Hollywood, close quote. And I would have to agree with that. And I'd add that the story will make for a very dark movie. So I have a few points about lessons for corporations. I'm going to tick those off very quickly and then let my colleague comment on all of this. I see the lessons for this audience as relatively simple and straightforward. Do business properly in the first place. This whole series of dark events would not have begun to unfold if Texaco had simply behaved in a responsible fashion and not spewed waste oil all over the place and not dumped tainted production water into streams in the middle of the rainforest. Lesson number 2, think twice about trying to chase lawsuits out of the American court system under doctrines like forum nonconvenience. It is altogether possible that this could have been resolved one way or the other on the merits or through some modest settlement all the way back in the 1990s by Texaco if Texaco had simply joined the battle on the merits in New York under American evidentiary standards with American legal procedures. Instead, Texaco chose the procedural route, and as a result, the shareholders of Texaco and then Chevron have now spent hundreds and hundreds and hundreds of millions of dollars, perhaps $1 billion over time, on legal fees. Consider settlement. That's sort of a subpart of point number 2. Maybe you should sort this thing out on the merits rather than fight the procedural fight. And finally, while this RICO counterpunching strategy looks very appealing to many corporate interests at this point, and Chevron is being held up as a model. This is how we should deal with far-flung mass litigation. I would warn corporations about that strategy. I think that it's very possible that as Donziger appeals that RICO finding to the Second Circuit, which he is appealing, and he has very skilled counsel filing that appeal on his behalf, that the Second Circuit is actually going to be quite anxious about this whole situation. Will be anxious about the argument that a mass lawsuit accompanied by a sophisticated media pressure campaign is the same as an extortion racket. Why will they be anxious? They'll be anxious because a lot of mass litigation could be framed that way, and the proposition from the corporate side that all mass litigation is one big extortion racket may not hold muster. It is altogether possible that the Second Circuit is going to, as I say, be uneasy and not necessarily uphold all of the remedies that Judge Kaplan put in place. So I would say think twice about RICO. Thanks.
Thank you, Paul. Eric?
Thank you very much, and thank you for having me. One of the benefits that I had in agreeing to present here is I got an advanced copy of Paul's book. I got to read it already. It's a great read. I would highly recommend it. And I've had the unique perspective of having followed the Chevron litigation and the Aguinda litigation for over 13 years, since 2001, because it was in 2001 that my client was sued for alleged misconduct in the same part of Ecuador, in the Sucumbíos province, arising out of the spraying of herbicides part of Plan Colombia. We made one significant strategic choice that was different than Texaco made, which was we stayed in the United States, and as a result, we've sort of gone down a separate path, but for the past 13 years, we've also been following the Chevron litigation as the path not followed, which is a very unique experience to have as a lawyer. And a number of the attorneys and the experts and the arguments that were made were parallel to some of the arguments that were made in our case, but the outcome was vastly different. Our case was thrown out as far as property damage and personal injury claims based upon a lack of expertise, which Chevron, when they were in Ecuador, was not able to, the arguments Chevron was not able to make. Now, I would like to focus my talk on some of the legal issues that have arisen from the Chevron litigation, and there are a ton of legal issues that can fill up seminars on their own. I'm not going to be able to get to all of them. There's fascinating issues with First Amendment rights and the film that was sort of the downfall of Donziger. There's issues with respect to third-party financing, and there's collateral litigation now with the people who did the third-party financing for Donziger. That is an area that is burgeoning now of third-party financing of litigation that is of significant concern. Issues with international enforcement of judgments, international arbitration. There's lots of issues that are just fascinating in this case. I'm going to focus on three issues. The forum nonconvenience decision, the use of 28 U.S.C. 1782 to obtain discovery in the United States for foreign legal proceedings, and finally the RICO allegations and how they were used in this case and how they've been used in some other cases. Now, first, the forum nonconvenience decision. And as I stated, we faced this exact same decision in our case at the same time that Chevron or Texaco faced its decision. Our case was filed in 2001. It was actually filed after the second district court ruling in favor of Texaco on forum nonconvenience grounds, but before the Second Circuit affirmed it. And the problem that Texaco had and the problem with the forum nonconvenience strategy is there's a poison pill. As a result of a U.S. Supreme Court case called Piper Aircraft, if you're going to make a forum nonconvenience decision, you have to consent to the jurisdiction of the foreign country. So you have to agree, and Chevron had to agree, or Texaco had to agree, that they would be amenable to process in Ecuador, where otherwise they might not have been. Now, that being said, and although we made a different strategic choice, there's a lot of 20/20 hindsight viewing of Chevron and Texaco's decision as being sort of a crazy decision and who would do it. It was not all a crazy decision. It was, in fact, the settled wisdom of how you deal with this type of litigation at the time, because, and the statistics, at least back at that period of time, was if you were successful in a forum nonconvenience motion, I think it was only like 5% of cases were ever actually refiled in foreign jurisdictions. And that's because there are many advantages to the U.S. jurisdiction, a U.S. court, that plaintiffs' counsel do not have or did not have in foreign jurisdictions. The procedural rules as far as discovery, as far as availability of punitive damages, as a no loser pay rule in the United States. There are a lot of procedural advantages to being in the United States for plaintiffs' counsel. And also, if you're in a foreign country that has an inquisitorial judicial system where the judge is in control of the litigation, plaintiffs' counsel is giving up a lot of control if they're no longer in a U.S. court. So there are a number of strategic reasons why corporations have and still do use forum nonconvenience. And really the key strategic decision that you have to make is what is the country you're going to? And I think that was the point where Chevron made or Texaco made a mistake in how they assessed Ecuador as an alternative forum. We were very afraid of going to Ecuador for some of the reasons, and I can't claim that we had any idea of the foresight of what would actually happen to Texaco and Chevron, but the idea that Texaco had in mind that we have a favorable legal framework in Ecuador, well, as Paul mentioned, that works just as fine until Ecuador decides to change the law, which is what they did. That also happened in another lawsuit involving DBCP pesticide in Nicaragua that Dole was involved in, I'll talk about in a minute, where Dole thought that they would be better off with a forum nonconvenience, same period of time, and they kicked their case to Nicaragua, and Nicaragua passed a special law, and all of a sudden the legal framework changed. But that was part of Texaco's determination. Texaco also had a release from the Ecuadorian government that they thought would therefore be complete defense in Ecuador, which does seem reasonable if you have a legal system that has any sense of fair play or structure to it, but that went by the wayside. And they also thought they had a favorable government in Ecuador. The problem there was that the Ecuador government kept changing. They had 7 different presidents in about a 10-year period, and they ended up with Rafael Correa, which was probably the worst draw they could have had. So that is where sort of the forum nonconvenience decision went wrong. But what happened to Chevron subsequent to that forum nonconvenience decision is also, even within the litigation, an interesting case study. And there's materials that I believe the Washington Legal Foundation has put up on their website. It's an article I wrote a few years back talking about the forum nonconvenience decision, both by Texaco in Ecuador and also by Dole and some other folks in Nicaragua, which were 2 major mass tort litigations back in the that were filed in the late 1990s, where the corporations made the standard and the settled wisdom choice of forum nonconvenience. In both cases, they went down to those foreign countries. The foreign countries, through a variety of fraudulent conduct and through changing of the law, ended up really hammering the defendants. I think in the DBCP litigation, there were judgments in Nicaragua of about $2 billion, none of which have been enforced in the United States for similar reasons that hopefully the Chevron judgment will never be enforced. So you have what happened in the foreign countries, but you also have an interesting history of what happened in the United States, because in both of those litigations, the Chevron litigation and the Dole litigation, there were also offshoot litigations filed in the United States, where they, after the forum nonconvenience decision, other lawyers tried again to file lawsuits in the United States, and those cases went forward in the United States. And what happened there, similar to what happened in my case, is that they couldn't prove their case in the United States, because in the United States, for whatever criticisms we may have about certain jurisdictions and hellholes and what have you, in the United States, the judges are professionals. The judiciary is, at least compared to foreign countries, it's honest, it's trying to do the right thing. And in both litigations, when those cases were brought in the United States, the fraud was uncovered, the cases were thrown out, attorneys were sanctioned. And so that provides a sort of a point-counterpoint, in addition to the experience that we had with our case out of Plan Columbia, where, again, in the United States, with the United States rules of evidence, we were able to get the case thrown out. And just one passage that jumped out at me from Paul's book was one of the many quotes from Donziger in the outtakes of this film, was Donziger talking about how he was going to deal with science and scientific evidence in Ecuador. And he stated in one part of the movie, science has to serve the law practice. The law practice doesn't serve science. And that's pretty much the mirror image of the rule in the United States, at least in federal courts, where law lags science, and the famous Posner quote from the Rosen case. In the United States, you have to actually prove your case with science. And even putting aside the issues of the fraud overseas, that rule is a strong tool for defendants. In our litigation, in the Plan Columbia litigation, plaintiffs weren't able to establish through reliable science any of their claims, and that's why we were able to prevail. So let me move on to the second issue, which is 28 U.S.C. 1781. And that's really a fascinating issue that I think may have some repercussions down the road that may actually not be as useful for corporate defendants. Under that statute, you can obtain discovery in the United States for legal proceedings overseas. And as Paul mentioned to a certain extent, Chevron was able to get huge amounts of information, not only the outtakes of the film Crude, but you also got discovery from the US-based consultants who were sort of engaged in the fraud and who had lots of information uncovering the fraud, some of the attorneys that worked in the United States, third-party financiers. Chevron got a whole bulk of discovery they would not have otherwise been able to get, which allowed them to establish their fraud. But if you recall earlier when I was talking about the forum nonconvenience decision, and one of the reasons why you might be better off in a foreign court than in a U.S. court, being that the U.S. court has discovery rules that are much more aggressive than foreign countries. Corporate defendants now have to worry about the law that has now been established. 28 U.S.C. 1782 was not really that widely used before the Chevron litigation. It now there's case law throughout the country, and in fact, in the Chevron litigation, the plaintiffs used 1782 against Chevron. They were able to get discovery from Chevron's experts and Chevron's consultants. And so for defendants now, corporate defendants, if you're overseas in litigation, you have to be aware of the fact that U.S. discovery rules may now apply to you through 1782 in a way that previously at least had not been a common experience. Let me turn to the RICO rules quickly. I want to leave time for some questioning. The RICO statute has now been used a number of times to address fraudulent mass tort litigation. It was used by CSX in asbestos litigation. Garlock Industries is using it in asbestos litigation. Ringling Brothers actually also filed the RICO suit against some activists that have brought lawsuits against them for factually unfounded claims. Now, I do agree with Paul to an extent that RICO is not the cure-all for all mass tort litigation. I have lots of problems with mass tort claims that I don't have time to go into now. But for a RICO claim, you need to have fraud, which they had in the asbestos litigation. You need to have more wrongdoing than just this sort of pressure of mass tort litigation and the general problems that you find throughout that litigation. So I don't think RICO is a cure-all for corporate defendants. But in a situation where you have, and it's becoming, I think, more common now as the plaintiff's bar has got more flush with money through asbestos and through the tobacco litigation, where plaintiffs' counsel are now trying to sweep up large numbers of plaintiffs and aren't actually establishing the attorney-client relationship with individuals as opposed to trying to create a mass to force corporate defendants to the bargaining table. There are going to be circumstances where you're going to find plaintiffs' counsel are pushing the line even beyond anything that would be allowed under the law. They're engaging in fraud. They're engaging in misconduct. And I think the RICO statute does provide, hopefully, a tool that will at least discourage the most serious abuses, and will allow a defense to fight back when those abuses do occur. Briefly, with respect to the Second Circuit appeal, which raises a lot of interesting issues, and I think the RICO issues are going to be an interesting decision for the Second Circuit. If bad facts can make bad law or a different law, you have here a case where the facts, I think, clearly establish RICO. There was fraud, there was bribery. Read Paul's book. I mean, anything you can imagine. The mafia has got nothing on these people, to a certain extent. So in this case, I think all the findings were appropriate. Where the Second Circuit is going to draw a line to try and keep this in a box may be a separate question. But I think the key issue also for Chevron is that whatever happens, the factual findings in this case, which are meticulous, and actually Paul is now in some ways validated through his own independent investigation, those factual findings are going to remain. And for Chevron, the name of the game here now is enforcement, and whether or not the plaintiffs are going to find any forum where they can try and enforce any of the judgment against Chevron. And now Chevron has an extraordinarily powerful weapon with the factual findings that were made in the Southern District of New York in order to try and block that. With that, let me open the floor up for questions, and I will take my seat. Thank you.
I wanted to reiterate what Eric had said, that the Forum Nonconvenience article that he wrote is on the WLF webpage where you all went to sign in, so please feel free to click on that link. I wanted to pick up on what you had said with regards to the RICO case, just to clarify for the audience that in RICO you can seek either damages or injunctive relief. In the situation with Chevron suing Donziger and the others, they decided to not pursue damages at all. Is that going to be a relevant issue going into the Second Circuit appeal? And also, what does that say about what you said with regards to perhaps their real goal was to get the facts out there found by a federal judge?
Well, Chevron made the decision to, well, I'm not going to state that I know exactly all the reasons that went into this, but one of the consequences of the decision only to seek injunctive relief was that the decision would be made by a judge. And you would then get not only a ruling in your favor, but you would get a detailed opinion in your favor. I don't know that a jury would not have found the same or reached the same conclusion hearing all the evidence, but a jury will just sign a jury judgment form in favor of the plaintiff. Here what you have as a result of going with a judge is a massive factual recitation, findings by a court that allow you to, again, use that for to prevent enforcement. So that, I think, was the reason. Now, will that go up in front of the Second Circuit? Yes, we know it will. It's already raised in the Second Circuit briefing as to whether or not that, whether there's a private right of action for equitable relief under RICO, and the Second Circuit will address those issues. And as I said, for Chevron, well, obviously they want to prevail. The big victory they had, I think, which is secure, is the factual findings that the judge made.
Yeah, I think that makes sense, and I think one of the fascinating things before the Second Circuit will be whether the Second Circuit entertains the invitation of a new player in this drama who has appeared only on appeal of the RICO case, and that's Professor Bert Newborn of NYU, who has now parachuted into the case to represent Donziger's clients. The Second Circuit is actually going to hear two appeals, one from Donziger and his lawyer, one from the Ecuadorian, the alleged victims. They are now represented by Professor Newborn, pro bono, I might add. And Professor Newborn's papers, if you read them, his first round of papers, between the lines read more or less like this. Whatever you do to this guy, this lawyer over here, whatever you do to punish him, sanction him, what have you, preserve something for the unsophisticated Ecuadorians. And he uses terms like that. I don't know how the Second Circuit's going to react to that, but he is making an explicit appeal to them, I think, that you may separate out some of the legal issues from the factual issues and so forth. So we'll see how Professor Newborn handles that in oral argument, and then, more importantly, how the Second Circuit handles it.
Yeah, and just to give a little bit of legal framework for the argument that's being made in this brief, the argument's being made that in the appellate process in Ecuador, the appellate courts review the factual findings de novo. And so the argument is that since the judgment was affirmed and with slight modifications through 2 rounds of appeal in Ecuador, those judgments somehow cleanse the verdict, the judgment against Chevron, because they're not relying upon any of the fraud that took place in the district court. Now that's sort of a fruit of the poison tree. I don't know how you can de novo review fraudulent facts and therefore find the actual facts. I don't think that argument really makes any sense, but that is the argument that is being presented.
Absolutely right. Yeah.
One of the arguments that Professor Newborn is making, and I think that Donziger's lawyer is making as well, is there's an estoppel here because Chevron, Texaco then agreed to abide by the foreign nonconvenience decision and fight their fight down in Ecuador. They are stopped from being able to now complain about the outcome. Do you see that as a winning argument? Well,
in a word, no, not in legal terms. It has a certain surface appeal from just a kind of common sense point of view, a kind of gotcha point of view. I mean, Texaco in the 1990s expended a tremendous amount of energy invoking eminent Ecuadorian jurists and legal scholars submitting their affidavits under oath that the Ecuadorian legal system is just okie dokie by every standard. And Texaco said, please, throw us into that briar patch. That's where we want to go. So there's a common sense argument. Oh, you got what you want. You got what you asked for. Now live with it. But that doesn't actually take into account the level of fraud that then ensued in Ecuador. If things had operated, a little bit less fraudulently, a little less feloniously down there, I think that common sense argument would have a lot more force. Here, if the courts down there have basically produced a nullity, a judgment that has no foundation, there's nothing beneath it, I don't see how the estoppel argument works.
Yeah, I don't want to be pejorative to fraternity houses, but I sort of view this as the fraternity house defense or the she asked for it defense. Nobody asked to be a victim of the type of fraud that Chevron was subject to in Ecuador, and the facts that emerged over the past 10 years of litigation are above and beyond anything that one could realistically imagine. And there is no defense for that. Nobody asks for that, and therefore deserves what they get. So I don't think that defense will succeed.
So one of the more, I think, fascinating things of Paul's book is the juxtaposition of the judges in Ecuador, the judiciary there, and the judges in the U.S. and the judiciary here. How much of a factor do you think it was for Chevron in terms of their strategy going forward that they drew Judge Kaplan rather than another judge in the Southern District? I think that's an important thing to talk about in terms of the importance of a judge versus another judge here in the U.S.
Yes. I think that's very fair. While the judges are not machines, judges are not entities without personalities and without particular intellectual approaches, and you're certainly not going to find a more independent-minded or more aggressive, and some might say even a more irascible judge sitting on the federal trial bench today than Judge Kaplan, who is widely admired for his intellectual skills and, frankly, intimidates a lot of people because he's very, very tough on all parties in front of him. He'll scold a federal prosecutor as quickly as he will a criminal defense lawyer. He'll reject guilty pleas, as he just did a few days ago in a very important terrorism case because he thinks it's not appropriate, even though the parties have agreed on it. So getting Judge Kaplan, who is going to be no shrinking violet under any circumstances, I think was relevant. That said, as Eric is pointing out, with this degree of misconduct proven, with this amount of contemporaneous evidence, not testimony looking back through time, but the actual emails taken from the hard drives of the suspect lawyer, this extraordinary surveillance tape derived from the field tapes of the documentary film, you normally don't have that kind of evidence. And the 1782 proceedings that Chevron undertook in front of Judge Kaplan, they also undertook that in 16 or 17 other courts around this country. And they got, I think it was 8 total rulings where other judges, not having to get as far into the case as Judge Kaplan got into the case, but other judges basically said, I've never seen anything like this. I don't know how the Ecuadorian courts work, but if they've got courts, this has got to be fraud there too. I grant Chevron its discovery request, even though there's an attorney-client privilege defense. We've got a crime fraud exception here, and the judges said one after another, this is crazy. So I think if the case had ended up before one of those judges, we would have ended up at the same place, maybe with a little bit less of Judge Kaplan's, shall we call it, flair.
Yeah, I do think that Chevron was fortunate to have a judge that would go to the detail that Judge Kaplan went in his opinion. But we have another example with a California state court judge in the Dole litigation, where there was actually, as I had mentioned in my remarks earlier, there was fraud down in Nicaragua, and there were with the DBCP litigation with banana workers. There's a lawsuit brought in California, and they're actually they actually went through a whole trial, and they won a verdict for some plaintiffs in front of a California state court judge. And they were going forward with more plaintiffs when the evidence of the fraud came out. And they were in front of the defendants were in front of a judge that would not be considered a pro-defense judge, a judge that had actually been, presided over trials where plaintiffs on what we now know was fraudulent evidence had prevailed. But when she found out about the fraud, she had an extraordinary evidentiary hearing where, she had, I can't remember how many days of testimony, and she came out with a scathing opinion. Which is just as scathing as Judge Kaplan's opinion here, throughout the prior judgment and put an end to that litigation. So when you have fraud on this level, I agree with Paul. No judge is going, in the United States, is going to sit for that.
I think a lot of this, and I think you probably both agree with this, wouldn't have gotten to this point but for the outtakes from the Crude movie. That really was the kicker in a lot of ways.
Well, it was the crowbar,
Right.
because it was the discrepancies in the several versions of Crude that were available that Gibson Dunn, Chevron's law firm on the RICO counterpunching lawsuit, brought to Judge Kaplan and said, Judge Kaplan, we see here some whiffs of fraud. There's been a scene excised that's incriminating to the plaintiffs. That troubles us, and we want to see the rest of what this filmmaker shot. The judge not only said yes, despite the First Amendment issues there, but I think that set the tone for other orders that he entered that allowed Chevron to get a hold of not just this cinematic material, but Donziger's personal musings, his diary to himself, and all of his emails. So in that sense, you don't really get the most incriminating evidence from the outtakes. That's more the sort of dramatic stuff, the rhetoric. But that was the opening mechanism that I think helped encourage Kaplan to say, you know what, this lawyer, Donziger, is not cooperating with the discovery process. There's evidence of dishonesty here. I'm going to lean on him. And then when Donziger failed, for example, to offer a privilege log when he fought the effort to get his private papers, that was the thing that set off Kaplan in the end. And Kaplan entered an opinion, now known as the Donziger waiver by shorthand, that basically said turn over all of your files to Chevron. And then the Second Circuit upheld that decision. That was actually litigated, that waiver. Second Circuit praised Judge Kaplan, said he exercised all the discretion a judge should have. He was patient, he waited. The litigant was dragging his heels. Sorry.
Yeah, and there is an associate, it may not be an associate out there, an associate now, maybe he or she is a partner now, I don't know the name of it, but there was somebody who was in a room somewhere looking at endless tapes of this film who noticed the difference between what was on the Netflix version and on the official version. If this had happened 10 years before, we didn't have Netflix, that would not have come out. Frankly. And
can I add a detail to that?
Yes.
A little anecdotal detail. That associate was central. That's a Gibson Dunn lawyer, and it's always nice to humanize these little episodes. Of course, the private eye firm that was working with him alongside, they'd like to take credit for it too. But let me
I'll give it to the attorney.
Let me add a third element, which is very pertinent to your point about if this had happened 10 years earlier. They were able to accomplish this because they were using facial recognition software. This was not something that the human eye, they were examining this film frame by frame, and they were using software of the sort that didn't exist before. And they were able to see that they were tracing who's in what scenes, and that helped them notice that a member of the plaintiff's legal team showed up collaborating with the supposedly neutral court-appointed expert, and so that's actually how that whole thing unfolded. It's quite fascinating.
Yeah, it's going to be interesting to see the impact that's going to have on the plaintiff publicity model in mass tort litigation. I mean, this idea of having a film with your claim is sort of a standard thing that was done in a lot of cases. Obviously, plaintiffs' counsel are going to be having to think twice about that. Documentary filmmakers are going to have to think twice about that. I don't know if there's anything that filmmakers in this case could have done to, if there's fraud underneath it and you're filming everything, you're going to catch some of that.
I would disagree with that. It was very significant to the Second Circuit in upholding Judge Kaplan's order, ordering the filmmaker to disclose all of his field tapes. It was significant to the Second Circuit that the Donziger plaintiff team had some degree of editorial control over the film. It is simply not the fact that most journalists will grant one of the litigants editorial control. When the litigant says, please excise that scene, they go ahead and excise the scene. I've never done that, and I can't remember anyone even, the situation doesn't come up. Why was Donziger even seeing the raw version of the film so that he'd have an opportunity to ask for it to go? So this filmmaker was operating in a way that one would hope is outside the norm. And let me add one other point. The terrible thing about that Second Circuit precedent is that it's based only on two grounds: Donziger's editorial influence on the film and the fact that he solicited the film in the first place. as a journalist, I think that first point is actually completely irrelevant and terrible law. The idea that there's something wrong with a combatant going to a journalist and saying, come pay attention to me, there's nothing wrong with that. That's where most journalism comes from at all levels. Editorial control, not so good. But the third element that showed that this was not a normal piece of news gathering and news presentation was that this film was financed by the guy who was friends with Donziger and who was financing the lawsuit. Sadly, that fact was apparently not known to Gibson Dunn, therefore not argued to Judge Kaplan, and is not in the Second Circuit opinion. I think that's terrible, because that would have set this situation off as truly exceptional. If that were part of the law, then I wouldn't worry about it, because I would never dream of taking financing from one of the litigants. Another ripple. We now have some, in my humble opinion, very bad First Amendment law in the Second Circuit. Again, thanks to Brother Donziger.
So 2 days ago, the Fourth Circuit issued a decision which was an appeal of one of the discovery actions that Chevron had brought. Can you talk a little bit about that and how that might impact the RICO case?
Well, the Fourth Circuit opinion, I think, was just a continuation of the waiver that the Second Circuit found. Yes. So as Paul mentioned, there were these proceedings, 1782 proceedings, all over the country to get documents that could be used by Chevron, not only in the Ecuador litigation, but they have ongoing international arbitration. And so this was another one of those proceedings. It was against attorneys who were trying to claim privilege for their communications, and the Donziger waiver was applied against them, and the Fourth Circuit looked at what the Second Circuit found, which was affirming what Judge Kaplan had done, and agreed with it. So I don't know that it changes the litigation much. It's just more evidence of how effective Chevron has been, and really the breadth of documents that they now have at their use in again, not only continuing with the RICO litigation, but there's international arbitration. Yeah. This battle is going on multiple fronts in multiple countries. Enforcement action still pending in a couple of countries.
Canada, Argentina, Brazil.
Right.
Yeah.
So
let me add one, again, on the factual level. I agree with what Eric said on the legal level completely. I don't think this was significant in legal terms, although in general impressionistic terms, it is significant that another federal court of appeal takes a look at what happened in New York and said, we are with our brothers and sisters in New York. We are with what the Second Circuit did. But as a factual level, why is Chevron going after this particular pair of lawyers? There, I think I can fill in a little bit of the blank. This is a husband and wife team who had been kind of junior lawyers to Donziger throughout. And the Fourth Circuit opinion actually filled in and helped explain why these particular people might be significant. They apparently worked on one of the central plaintiff's internal memos, which was never filed in the litigation in Ecuador, but portions of which turned up in the 2011 judgment verbatim. These two lawyers, it turns out, were the authors of that key memo, which for reasons I won't bore you with is called the Fusion Memo. Now, I think Chevron believes that these lawyers have things on their hard drive that actually weren't on Donziger's hard drive. And if there is more evidence of the fraudulent nature of the final judgment itself, that could actually augment the factual record that Judge Kaplan has already established. And I think that could be very significant in subsequent enforcement rulings. Because if the argument is this judge who signed this didn't write this ruling, that's sort of like the ultimate explosive device to blow up a supposedly legitimate judgment in Ecuador. Yeah,
and I think it bears repeating how effective Chevron's been with its 1782 strategy. I mean, they every time they look under a rock, there are worms that are coming out of it. And so every 1782 proceeding they win, they seem to get documents that make your jaw drop as far as the fraud that's being uncovered. So certainly continuing to prevail and continuing to push that strategy has got to be going to work out well for them.
And it should be deeply troubling to the plaintiff's bar, to the rule-following, law-abiding plaintiff's bar. Look at the precedents that are being set in this case, whether it's the First Amendment or it's on discovery issues and the overcoming of attorney-client privilege. Courts would be much more hesitant to to say to lawyers, you've got to turn over your files to the defendant, were it not for the cloud of fraud that the Donziger team brought here. This is emboldening courts to do things that courts normally do not like to do in this country. Attorney-client privilege is a serious matter. And just as environmentalism generally has been discredited by this, what has been deemed this extortionate lawsuit, all kinds of mechanical precedents are being set that are going to reverberate for years, that are going to hurt people on the plaintiff's side. And I think that's very significant.
Yeah, and Paul has a section at the end of his book where he talks about what's happened in the plaintiff's bar as a result of, in my mind at least, all the money that is poured into the plaintiff's bar. More money, you're getting more corruption. You're getting lots of plaintiff's attorneys who are go over to the dark side, as I think Donziger said that what happened to him. And we have lots of attorneys now that we all know the names of who have been indicted, who are now in jail. And so it's not only Donziger that is emboldening courts to look more closely at this. It's sort of a lineup now of rogue plaintiffs' counsel that is giving the courts reason to look behind what's being said. And lots of times when you look behind, particularly in the mass tort litigation, where, as I said, you sort of are losing the actual attorney-client relationship. A lot of times you find the plaintiff's counsel are driving the bus, and sometimes they're breaking the rules when they're doing that.
Let's emphasize, just for clarity, that Donziger has not been charged to date with any criminal infraction. All of these proceedings in the U.S. have been in a civil context. Although my rival and colleague Roger Parloff recently wrote a very interesting piece for Fortune.com, which was headlined "Where's Preet?" ? And the point of Roger's opinion piece was he was wondering, given Judge Kaplan's findings under a civil, clear and convincing evidence standard, why across the street at the U.S. Attorney's Office in the Southern District of New York, U.S. Attorney Preet Bharara has not opened a criminal investigation. I think it's a very interesting question, but it does underscore the point that so far as we know, there isn't a criminal investigation.
Do you think that Donziger never really calculated the risk well of not being able to collect on his judgment? That was a point that I thought you made interestingly in your book. Do you think it really dawned on him that he wouldn't be able to at some point?
My best assessment of Stephen Donziger is that he fought each day's, each week's, each month's battle without looking out to the future. That he got into a cycle of combat for the sake of combat, ad hominem attack for the sake of destruction, and eventually lost sight of the fact that he was supposedly leading a legal enterprise, and instead began to see it almost as an existential exercise. He was the case was him, and he couldn't separate those two things. I think, sadly, the interests of his clients, which might be reflected in an enforceable judgment as opposed to any darn judgment that we might get through any series of machinations, began to fade over time. I think this was potentially a legitimate lawsuit when it was filed in 1993. This was before Texaco had cleaned anything up, before Texaco had a release. You had possibly a cause of action back then, particularly in front of a U.S. court, but things changed over time.
I'd like to follow up on 2 points on there. One, just because I think it's important to note, Texaco, what Paul just mentioned, that Texaco have gone in and cleaned up their sites. Texaco did do remediation in Ecuador. There was at the stage where there was still some independent review going on. An independent scientific team went down to look at one of those sites, and it was their findings that sort of led Donziger to say we can't have this, and things went off track because the findings were not favorable to his clients; they were favorable to Texaco. But as far as what was going on with Donziger's mind, I think like all criminal proceedings, I consider this one to be, he thought he'd get away with it. So you don't have a problem enforcing a judgment if nobody realizes that the judgment is fraudulent. And I don't think he ever expected it. In fact, there's one outtake from the crude film where one of the consultants is saying, what happens if they get this outtake of the film? And they say, Donziger says you can't get that discovery in Ecuador. He didn't think about 1782. Never occurred to him that people would find out.
One final question. Why do you think some environmental and human rights activists continue to support Donziger and the crusade that he went on? And what do you think that tells us about why the whole thing ended up why Danziger's Crusade ended up collapsing in the end.
I want to question your premise, although I will actually answer it because there is something to your question. And I'll do it in a very self-serving way. Fred Krupp, president of the Environmental Defense Fund, endorsing my book, Barrett's Law of the Jungle is a cautionary tale, a deeply reported, well-written reminder that to be credible and effective, the fight against environmental misconduct must be waged within the rule of law. Mainstream environmentalists are not backing this lawsuit. Fred Krupp has endorsed my book, which takes a very skeptical look, to say the least, at Danziger's tactics. David Yarnold is right above him, president and CEO of the National Audubon Society. Danziger's support comes mainly from groups which, sad to say, I think, are not to be taken terribly seriously. You know, just like you shouldn't lump all plaintiffs' lawyers together, there are some of the most honorable people I know file only plaintiffs' lawsuits. Some of the most honorable people I know have spent their lives dedicated to fighting on behalf of the environment and suing the large industrial companies. They do it within the law. They do it from an institutional base where there's a long-term program of trying to move the law in an open way through litigation, legislation, and so forth. You might disagree with them, just like you might disagree with people, with your clients on the corporate side. That's all totally fair game. So, Environmental Defense Fund, National Audubon Society, they're not backing him. What he got, the backing he got, was from celebrities. And we often confuse these things in this country in our celebritized society. We think that if Sting is on your side, well then all the environmentalists, no, that's not the case. Sting is a rock star, and I don't actually expect Sting to know what he's looking at when he's shown waste oil pits. So I just think that that's crucial. I mean, there are groups that are backing him. I would question the significance of those groups. And in one particular case, I would point out that Danziger has been central to financing the group, which has served over a period of time as his online mouthpiece, and you can make of that what you will.
Yeah, I do think, though, that it talks to the sort of David versus Goliath storyline that is prevalent in our society, and sort of the idea that, you know, corporations are bad, and they're always bad, and we'll just side up against them because we don't trust corporations, and anyone who's fighting them, we're going to back them. And one thing that, you know, I hope also maybe come out of this litigation is and the movie that will be very interesting to see, because Hollywood doesn't make movies in which the plaintiff's counsel is the bad guy.
It's always the first time.
It's sort of a realistic, or at least what I view as a more realistic view of what's often happening here, so that you don't fall into the sort of the knee-jerk reaction that a lot of environmental groups or celebrities have fallen into, in which they're just going to always assume that the corporation is the bad guy no matter what the evidence is. Yeah,
but the corporation wasn't the hero here either. Remember, we've gotten so far away from the original alleged problem. This is now litigation over litigation. Chevron has been able to don the mantle of the victim as a result of the corruption of the litigation. Let's remember, in the 70s and 80s, Texaco misbehaved. The pollution that was left behind need not have been left behind. With a modest amount of additional spending to clean up what should have been cleaned up in the first place, this whole situation could have been framed very, very differently. I'm not saying there wouldn't have been a lawsuit. I'm not saying there wouldn't have been leftist politics in the 2000s, you know, shaking a fist at the Yankee imperialists. All of that might have taken place. But in this case, as often is the case, there was some corporate misconduct, and then things kind of got distorted and out of control.
Right, and I think one thing that happened, though, because of the legal system that we ended up in, is, you know, while we can look at what happened back in the 80s and look at various documents and try and come up with a storyline, as I said, Texaco cleaned up the sites, and then there was another company, Ecuador, which has been running these oil fields since then, and by all accounts has done a horrible job. So there's lots of oil on the ground that is due to their operations. Because we did not have an actual objective scientific investigation, we didn't not have a honest legal investigation, I don't think you can say oh, any of that is Texaco's, and that they didn't do the remediation, because you can't trust any of the evidence that has come out of the Ecuadorian litigation.
Sadly, what Eric says is factually correct. Ecuador has, in fact, proved itself to be every bit as irresponsible in the 90s and the 2000s as Texaco was in the 70s and 80s, which in some ways is worse because it's the 90s and the 2000s and we know better now. And when I was in Ecuador doing some of my field reporting, out wandering around in the oil zone, I came across a live Petro-Ecuador oil spill happening in real time. Oil spewing out of a pipeline, running along the side of the road, running under the road, and into an agricultural field across the road. So this problem, 21 years of litigation, this problem continues to exist, and it's still unfolding today in Ecuador.
And one of the tragedies that Paul mentioned is it's not only that it wasn't uncovered because of the fraud, but Danziger, through his lobbying of the Ecuadorian government, has prevented or has tried to prevent any effort to clean up the oil contamination that exists there, which is really the most ironic, in some ways, tragic part of this.
Well, we will put a cap on it here. I want to thank both of you for joining us today and everyone online for joining us. If you have any colleagues or others that you know would be interested in seeing this, we will have it online as an on-demand file later this afternoon. I also want to mention anyone who's interested in the upcoming Supreme Court term, we will be doing our annual briefing preview of the Supreme Court on October the 1st, which is this coming Wednesday from 1:30 to 2:30. That will be webcast as well. And again, thank you for joining us today.
Hey, Eric, that was really good.
Yeah, no, it's fun.
I mean,